developer blocked my only access road with heavy equipment, so the sheriff read him the recorded easement. The first thing I saw when I turned off the county road that evening was the yellow arm of an excavator sitting sideways across my driveway, not parked near it, not working beside it, blocking it. Behind it were two dump trucks, a row of orange concrete barriers, and a white sign zip-tied to a metal post that read, "Private construction access, do not enter." I sat there with my headlights pointed at the machine, my work shirt still damp from a 12-hour shift, trying to understand how the only road to my house had become somebody else's construction zone while I was gone. Then a man in a clean black jacket walked over from the trailer, holding a clipboard like it made him a judge. "You can't go through here," he said. I lowered my window. "That road goes to my house." He glanced past me, toward the dark tree line where my place sat half a mile back. "Not anymore. This is an active development site." I told him there had to be a mistake. That road was my recorded access easement. It had been there long before his company bought the land around it. He smiled like I had just said something childish. "You don't own this road," he said. "You just got used to using it." That was when one of his workers dragged another barrier into place, sealing the gap beside the excavator. I stepped out of my truck and told them to stop. The developer raised one hand, calm and smug, and said if I crossed onto the site, he would call the sheriff on me for trespassing. Trespassing. On the only legal access to my own home. I stood there on the shoulder of the road while trucks rumbled behind him and dust rolled through my headlights. My house was close enough that I could picture the porch light glowing through the pines, but too far to reach without walking through mud, equipment tracks, and a construction zone they had no right to put there. So I did the only thing I could do without giving them the fight they clearly wanted. I took out my phone and started recording. I recorded the excavator, the barriers, the sign, the developer's face when he told me to find another way in, even though he knew there was no other way. And as I zoomed in on the permit board beside the trailer, I noticed something that made my anger go cold. Their permit listed grading, drainage, and utility work, but nowhere did it say they had permission to close a recorded easement. I never bought that house because it was fancy. It wasn't. It was a one-story place with faded blue siding, a gravel parking pad, an old mailbox that leaned a little to the left, and a back porch that creaked every time the weather changed. The kitchen cabinets were older than I was, the hallway floor had a soft spot near the laundry room, and every winter I had to fight the same stubborn draft under the front door. But it was mine. After years of renting apartments where I could hear strangers arguing through the walls, after years of saving every spare dollar and working overtime whenever it was offered, I finally had a place where the only noise at night was wind moving through pine trees. No upstairs neighbors. No landlord inspections. No one telling me what I could plant, where I could park, or whether my dog was too loud because he barked once at a deer. The house sat at the end of a narrow dirt and gravel road that cut through a wooded parcel outside town. It was not a subdivision road. It was not pretty. In the spring, rain carved little channels along the edge. In the summer, dust followed my truck like smoke. In the fall, leaves covered the ruts so completely that visitors sometimes thought they had made a wrong turn. But that road was the reason the property worked. It was my only way in and my only way out. The driveway connected my home to the county road, to work, to groceries, to the pharmacy, to the emergency room, to everything. The garbage truck used it. Delivery drivers used it. Utility crews used it. When my father was sick near the end, the ambulance used it twice, lights flashing between the trees while I stood on the porch praying they could find the address in time. That was why I knew the access was not casual. It was not some neighborly favor from whoever owned the surrounding land. When I bought the property, the title company had gone over it with me at the closing table. The woman slid the papers across the desk, tapped one paragraph with her pen, and said, "This is important. Your parcel has a recorded easement for ingress and egress across the adjoining property." At the time, I barely understood half the words. I just knew it meant I had a legal right to use that road. Later, I learned exactly what it meant. The easement was recorded with the county decades before I ever lived there. It ran with the land. It was written into the records, attached to my deed, and visible to anyone who bothered to do a proper title search. It gave my parcel the right to pass over that road for ordinary residential access, utilities, deliveries, maintenance, and emergencies. In simple terms, the land around me could change hands 100 times, but my access did not disappear just because a new owner found it inconvenient. For years, nobody challenged that. The old owner of the surrounding acreage was a retired farmer named Mr. Harlan. He mostly left me alone. Sometimes he waved from his tractor. Sometimes he asked if I had seen his missing cattle dog. We never had a written friendship, but we had the kind of quiet, rural understanding people use to respect. I used the road. He knew I had the right to use it. That was the end of it. Then he sold the land. At first, I did not panic. I heard rumors that a developer had bought the acreage for a new townhome project, 24 units with sidewalks, decorative streetlights, drainage ponds, and a marketing name that sounded like it had been created in a conference room. Something like Pine Ridge Commons, even though they cleared most of the pines during the first week. Still, I tried to be reasonable. People need places to live. Land gets developed. I understood that. I was not the kind of person who shows up at public meetings just to yell that nothing should ever change. I did not expect the woods around me to stay frozen in time forever. All I wanted was simple. Do not block the only road to my home. Do not tear up the drainage near my driveway. Do not use my access as a storage yard. Do not pretend a recorded easement is a suggestion. For a while I thought that would be obvious. The county had approved a site plan. The developer had engineers, attorneys, surveyors, project managers, and a polished website full of words like community, integrity, and responsible growth. Surely a company that large would know better than to trap a homeowner behind its construction site. Then the first letter came. It was printed on thick paper with the developer's logo at the top. The tone was polite, but every sentence felt like it had been sharpened by a lawyer. It said, construction activity would begin soon, that temporary access adjustments might be necessary, and that residents in the area should cooperate with posted safety instructions. Residents in the area. That was how they referred to me, as if I were just some random inconvenience near their project, instead of the owner of the parcel at the end of the legal access road running straight through their new investment. I emailed back the same day. I explained that my home depended on that road. I attached a copy of the easement page from my closing documents. I asked them to confirm that my access would remain open at all times. For 3 days, no one answered. Then I got a reply from the project manager. It was short enough to feel intentional. We are aware of historical access patterns, he wrote. However, active construction operations may require temporary restrictions. Please coordinate with site personnel as needed. Historical access patterns. I read that phrase 5 times. Not recorded easement. Not legal access. Historical access patterns. That was the first moment I felt the ground shift under the whole situation. Because people do not avoid the right word by accident. They avoid it when the right word gives someone else power. I printed the email and put it in a folder. At the time, I did not know how important that folder would become. I did not know I would soon be standing in front of an excavator with my headlights on, recording a developer who thought he could erase my rights with orange barriers and a smug smile. I only knew one thing. The road to my home was more than gravel and dust. It was the line between having a life I had built and becoming a prisoner on my own property. And if you have ever dealt with an HOA, a neighbor, a contractor, or a developer who acted like your property rights were just an obstacle to their plans, then you already understand why I kept every email, every notice, every photo, and every word they sent me. Because sometimes the smallest paragraph in a deed is the only thing standing between you and someone with more money deciding your home no longer matters. The first week of construction was annoying, but I told myself annoying was not the same thing as illegal. There were trucks passing the end of my road before sunrise. There was dust on my porch rail by lunchtime. There were backup alarms echoing through the trees, metal scraping against gravel, workers shouting over engines, and survey flags popping up in places where deer used to cross. I did not complain. I left earlier for work. I washed my truck more often. I waved at the flaggers when they let me through. I kept reminding myself that the land had been sold, the project had been approved, and change was part of life. But then their materials started creeping closer to my access road. At first, it was one pallet of drainage pipe set near the edge of the gravel. Then it was a stack of lumber, then a pile of crushed stone, Then a portable toilet placed so close to the road that my passenger mirror almost clipped it every time I drove by. One morning, a dump truck was parked halfway across the easement with no driver in sight, and I had to sit there for 20 minutes before a worker finally moved it. When I asked him to keep the road clear, he laughed and said, "You'll live." That became the attitude. Every time I said the word easement, they acted like I was talking about some ancient rumor. The foreman, a big man with mirrored sunglasses and a radio clipped to his vest, told me the county had approved the development, and that meant they controlled the site now. I said, "The site includes my legal access." He shrugged. "It includes our work zone." I tried to stay civil. I emailed the project manager again. I attached the easement language again. I asked for a written schedule of any temporary closures and an alternate access plan if they truly needed to block the road for a few minutes at a time. He replied the next afternoon with one sentence. "Please follow all posted construction instructions for your safety. Not a word about the easement, not a word about my house, not a word about how I was supposed to get home if they decided safety meant locking me out." 2 days later, they answered that question for me. I came outside at 6:30 in the morning, coffee in one hand, lunch bag in the other, and stopped dead on my porch steps. Down at the bend where my gravel road crossed onto the developer's parcel, there was a temporary metal gate stretched between two posts. A heavy chain looped through the middle. A brand new padlock hung from it. Beside the gate was another sign. Authorized personnel only. For a few seconds, I just stared at it, waiting for my brain to make it make sense. My truck was on my side of the gate. My job was on the other side. The county road was on the other side. Everything was on the other side. I walked down there and found the foreman standing near a skid steer, talking to two workers. I asked him who locked the gate. He did not even pretend to be surprised. "We did," he said. "You locked me in." He tilted his head like I was being dramatic. "You're not locked in. You're restricted from entering an active construction area. My driveway goes through there. That's not a driveway. That's a construction access lane." I pulled out my phone and showed him a picture of the easement page from my deed. He barely glanced at it. "Old paperwork," he said. "You people always come out here waving old paperwork. You people." That was the first time I understood what he really thought of me. I was not a homeowner. I was not a person with a recorded property right. I was an obstacle, a loose end, a leftover from before the land became valuable. I called the number on the construction notice. A receptionist answered from some office miles away and told me complaints had to be submitted by email. When I said I was physically blocked from leaving my property, she paused, then said, "Our response window is 7 to 10 business days. 7 to 10 business days." I had to call my supervisor and explain why I could not get to work because a developer had padlocked the only access road to my house. I could hear how ridiculous it sounded as I said it. I could also hear the worry in my supervisor's voice when he asked, "Is that even legal?" That afternoon, after several phone calls, the gate was open just wide enough for me to leave. But the message was clear. They could close it whenever they wanted. They wanted me to feel that. After that, the interference became constant. A pharmacy delivery driver called me from the county road and said he could see my mailbox, but could not get any farther because a dump truck was blocking the lane. The garbage truck skipped my pickup because the driver said the road was unsafe. A friend tried to visit on Sunday and turned around after a worker in a hard hat told her the property was closed to the public. Then, one evening, I came home and found the developer himself waiting near the trailer, leaning against a black SUV that probably cost more than my house did when I bought it. He smiled like we were about to have a business conversation. "I'll be honest with you," he said. "This situation isn't ideal for anyone." I said, "You mean the situation where your crew keeps blocking my legal access?" He ignored that. "Your property is going to be surrounded by construction for a long time, then by new homes, increased traffic, noise, lighting. Buyers don't love seeing an old private residence sitting awkwardly at the back of a planned community." I stared at him. "What are you saying?" "I'm saying you should consider selling before this gets more difficult." There it was. Not safety, not scheduling, not confusion over paperwork, pressure. He was trying to make my life so inconvenient that selling would feel like relief. I told him my house was not for sale. His smile thinned. "Then you need to understand," he said. "We can't redesign a multimillion-dollar project around one person who refuses to cooperate. That sentence stayed with me all night. One person. As if my rights weighed less because I was alone. That same night, my security camera at the front of the property caught two workers near my mailbox after dark. One of them unscrewed the small reflective address sign I had mounted years earlier so emergency vehicles could find my road. The other pointed a flashlight toward my house, then toward the camera, and they both walked off laughing. By morning, the sign was gone. That was when I stopped thinking of this as a construction inconvenience. This was deliberate. They were not just blocking my road. They were trying to erase the evidence that my home belonged there at all. The morning after my address sign disappeared, I did not walk down to the construction trailer and demand answers. I wanted to. I wanted to stand there with the security footage on my phone and ask the foreman why his workers were touching anything near my mailbox after dark. I wanted to ask the developer if removing the sign that helped emergency vehicles find my home was part of his safety plan. I wanted to tell every worker on that site that I knew exactly what they were doing, but anger was what they wanted from me. If I yelled, they could call me unstable. If I cut the chain, they could call it vandalism. If I moved the barriers myself, they could claim I entered an active construction zone and created a hazard. The more I thought about it, the more obvious it became that the entire situation was designed to push me into making one bad decision. So I did the opposite. I got quiet. I made coffee, sat at my kitchen table, and opened a new folder on my laptop. I named it Easement Interference. Then I created subfolders for photos, videos, emails, permits, county records, deliveries, and damages. It felt ridiculous at first, like I was overreacting to a neighborhood argument. Then I looked out my window and saw a dump truck crawling past the trees on the road I was supposedly not allowed to use. That cured the doubt. I started with the video from my security camera. I downloaded the full clip, not just the part where the workers removed the sign. I saved the file with the date and time in the name, then I copied it to an external drive and uploaded a backup to cloud storage. I took screenshots showing their faces, the flashlight beam, the address sign still attached before they touched it, and the empty post afterward. After that, I walked the length of my road with my phone. I filmed the gate, the padlock, the chain, the orange barriers, the tire ruts, the piles of gravel spilling into the easement, the portable toilet leaning toward the lane, and the muddy trench their equipment had started carving across the drainage ditch. Every few yards I stopped and narrated the date, the time, and exactly where I was standing. I did not add insults. I did not threaten anyone. I just described what the camera could see. This is the access road to my residence. This is the gate installed across it. This is the sign stating authorized personnel only. This is the construction equipment blocking the route between my home and the county road. When a worker shouted from a distance that I could not film there, I stayed on my side of the gate and kept my voice calm. I'm documenting the obstruction of my recorded access. He cursed and walked away. That clip went into the folder too. Next, I searched through the banker's box in my closet, where I kept every document from buying the house. Most of it was boring. Inspection reports, old insurance papers, appliance receipts, mortgage disclosures thick enough to stop a door. But buried under the title policy was the survey from my closing. I spread it across the kitchen table and pinned the corners down with coffee mugs. There it was, a thin line running from the county road across the adjoining parcel to my property, labeled as a non-exclusive easement for ingress and egress. The language matched the paragraph in my deed. It was not vague. It was not a handshake. It was not historical access patterns. It was recorded. I pulled up the county recorder's website and searched my parcel number. Then I searched the developer's parcel number. Then I searched the old farmer's name because I remembered Mr. Harlan from the closing documents. It took almost an hour of clicking through scanned pages that looked like they had been copied in the basement of a courthouse. But eventually, I found the original easement agreement. It had been recorded more than 30 years earlier, before my mortgage, before the townhome project, before the developer's company even existed under its current name. I downloaded the PDF and printed 3 copies. Then I noticed something that made me sit back in my chair. The easement did not only mention my right to drive in and out, it specifically included residential access, emergency access, utility access, maintenance access, and delivery access. It also said the servient estate owner could not unreasonably interfere with the use of the easement. Unreasonably interfere. I wrote those two words on a sticky note and put it on the front of the folder. After that, I stopped treating the developer like someone who misunderstood me. I started treating him like someone who needed a paper trail. I sent one email, short and clean. I identified myself as the owner of the parcel at the end of the recorded easement. I referenced the document number from the county recorder. I stated that the gate, chain, barriers, equipment, material storage, and removal of my address marker were interfering with lawful access to my residence. I requested that the obstruction be removed immediately and that they confirm in writing that access would remain open. I attached the easement. I attached the survey. I attached 3 photos. Then I waited. The response came 6 hours later from the project manager, with the developer copied. Your characterization is inaccurate. Any temporary limitations are necessary for site safety and construction sequencing. Please refrain from interfering with permitted work. There was that word again. Permitted. So I went after the permits. The next morning, I called the county planning department. I did not start with a rant. I said I was a property owner whose recorded access crossed an active development site, and I wanted to know whether the approved construction permit allowed the developer to close or obstruct that access. The woman on the phone got very careful. She asked for the project address, then the permit number from the sign by the trailer. I gave it to her. I could hear her typing. Then she said, I can't give you legal advice, but a building or grading permit does not normally extinguish a recorded private easement. That sentence went straight into my notes with the date, time, and her name. She transferred me to code enforcement. The code enforcement officer sounded tired, like he had heard every excuse in the county. He told me to submit a complaint online with photographs, the easement document, and a description of how access was being blocked. He also suggested I contact the sheriff's office if I was physically prevented from leaving or entering my property. Then he said something else. If emergency access is obstructed, that gets attention. I submitted the complaint that afternoon. After that, I called my title insurance company. I did not even know whether they would care, but I remembered paying for the policy at closing and seeing the easement listed in the paperwork. The representative asked me to send the deed, the title policy, the recorded easement, and any written communication from the developer. By then, I had all of it organized. For the first time in days, I felt something other than panic. Not confidence exactly. Control. The developer had equipment, crews, money, and a trailer with his company logo on the side. But I had dates. I had files. I had public records. I had video of his workers removing my address sign. I had emails where he refused to call my easement an easement. And now I had a county complaint number. Still, I knew documents alone would not be enough. I needed someone independent to mark the truth on the ground. So I hired a licensed surveyor. He arrived 2 days later in a white pickup with orange stakes, a tripod and GPS equipment mounted on a pole. He was an older man with a calm voice and the expression of someone who had watched 1,000 property disputes turn stupid because one side thought confidence could replace measurements. The foreman came over almost immediately. "What's this about?" he asked. The surveyor looked at him and said, "I'm locating a recorded easement." The foreman crossed his arms. "This is a controlled site." The surveyor did not blink. "Then you should probably want to know where the easement is." I stayed quiet, because that answer was better than anything I could have said. For the next hour, the surveyor worked along the road, checking points, comparing the legal description, and placing orange flags in a line that ran directly through the place where the developer had stored gravel, parked trucks, and installed the gate. Every new flag felt like a nail being driven into the developer's version of the story. When he finished, he called me over to the map spread across his tailgate. "The good news," he said, "is your easement is exactly where you thought it was." I looked toward the flags fluttering beside the road. "And the bad news?" He tapped one section of the survey with his pencil. "They've cut a drainage trench across it. If that trench isn't on the approved plan, they may have a bigger problem than blocking you." For a moment, all I could hear was the distant beep of a reversing loader. The developer had spent weeks acting like I was the problem. But now the ground itself was starting to testify. The surveyor's words changed the whole shape of the fight. Until that moment, the developer had been treating me like a stubborn homeowner who did not understand progress. In his version of the story, I was clinging to an old dirt road while his company brought new housing, new tax revenue, and a polished site plan to the county. But the orange flags told a different story. They did not care about his marketing brochure. They did not care about his SUV, his office trailer, or the way his foreman kept saying controlled site like it was a magic spell. Those flags marked the easement exactly where the public record said it was. They ran straight through the gate, straight past the gravel pile, straight beside the portable toilet, and straight across the trench his crew had cut into the ground. The next morning, I took the surveyor's preliminary map and drove to a real estate attorney whose name I got from my title insurance company. Her office was in an old brick building downtown, the kind with creaky stairs and framed courthouse maps on the walls. I expected her to glance over the papers and tell me this would be expensive, complicated, and probably not worth the stress. Instead, she read silently for almost 20 minutes. She looked at the recorded easement. She looked at my deed. She looked at the old survey, the new surveyor's field notes, the photos of the locked gate, the screenshots from my security camera, and the email where the project manager called my access a historical access pattern. Then she leaned back in her chair and said, "They know." I asked what she meant. She tapped the easement document with her pen. "This is recorded. It is not hidden in your personal files. It is in the county records. Any competent title search would have found it before they bought the adjoining parcel." I felt something tighten in my chest. "So they can't say they didn't know?" "They can say whatever they want," she said. "But if this easement appears as an exception on their title commitment, they purchased the land subject to your access rights." That sentence landed like a door opening. Subject to your access rights. For weeks, the developer had acted like his purchase gave him complete control over everything inside the boundary of his new project. He talked about construction sequencing, site safety, and multi-million-dollar planning, as if those words could crush anything smaller than his company. But he had not bought clean, unrestricted control. He bought land with my legal access already attached to it. My attorney asked whether I had a copy of the developer's title commitment. I did not. I thought that kind of thing was private. She explained that some documents connected to land transactions, easements, plats, permit submissions, and planning approvals could be found through county records, depending on what had been filed. She also said discovery could get more later if the dispute went that far. We started with what was public. Together, we pulled up the county recorder's database, the planning department portal, and the project file for the townhome development. It took some digging, but eventually we found a packet the developer had submitted during site review. Buried deep inside, after stormwater calculations and utility drawings, was a title-related schedule listing encumbrances and exceptions. There it was, my easement, not by my name, but by recording number, date, and legal description. The attorney turned the monitor slightly toward me. "They disclosed it to the county," she said. For a second, I could not speak. The developer had not merely overlooked my access. He had not been surprised by a document I pulled from an old closing folder. His company had submitted paperwork showing the easement existed, then turned around and treated me like I was inventing it. Then we found the second problem. The approved site plan showed my access road remaining open during construction. There was even a note, small but unmistakable, near the edge of the plan. Existing access easement to remain unobstructed unless alternate access is approved. I read it twice. Then a third time. Existing access easement to remain unobstructed. Those words had been sitting in the county file while I was being told to coordinate with site personnel, wait 7 to 10 business days, and consider selling before things became more difficult. My attorney printed that page in color. "This is why they avoided calling it an easement in email," she said. "They knew exactly what term mattered. The whole story suddenly became clearer. The developer's crew had not blocked me because the law was confusing. They blocked me because the easement was inconvenient. They needed room for trucks, staging, drainage work, and a construction entrance. Rather than redesign the site around a right they had purchased subject to, they tried to pressure the only person affected into giving up. I thought about the missing address sign. I thought about the locked gate. I thought about the developer leaning against his black SUV, telling me my property would become awkward once his planned community surrounded it. It had never been about safety. It had been about leverage. My attorney began drafting a demand letter while I sat across from her, listening to the keys click. The letter was not emotional. It did not call him a bully. It did not accuse him of trying to ruin my life. That was the strange power of it. Every sentence was colder and heavier because it relied on documents instead of outrage. It identified my parcel. It cited the recorded easement by document number. It referenced the approved site plan requiring access to remain unobstructed. It listed the gate, chain, barriers, stored materials, heavy equipment, block deliveries, removal of the address marker, and drainage trench as interference with lawful ingress and egress. It demanded immediate removal of all obstructions from the easement, written confirmation that access would remain open, restoration of the road surface, preservation of all site communications and camera footage, and reimbursement for damages, survey costs, and legal fees. Then came the part that made me exhale slowly. If the developer did not comply, my attorney would seek injunctive relief. I had heard the word injunction before, but never in a situation involving my own gravel road. She explained that if a court agreed, the developer could be ordered to stop interfering with my access immediately. Not months later after a full trial. Immediately. And if they violated that order, the consequences could become much more serious than a neighborly disagreement. The letter also copied the county planning department, code enforcement, the developer's registered agent, the project manager, and the site contractor's office. Before sending it, my attorney looked at me over her glasses. "You need to be ready for them to act offended," she said. "People like this often confuse being held accountable with being attacked." She was right. The response came the next day, not from the project manager this time, from a lawyer representing the developer. The letter said my claims were exaggerated. It said any obstruction was temporary and necessary for safety. It said my continued complaints were causing delays and increased costs. It said the developer reserved all rights, including the right to pursue damages if I interfered with permitted construction activity. I read the letter in my attorney's office, and for one horrible second, the old fear came back. They had more money, more lawyers, more influence. Maybe they could bury me in paperwork until I gave up. Maybe that was the plan all along. But my attorney did not look worried. She picked up the developer's lawyer's letter, turned to the second page and said, "Notice what they don't say." I scanned it again. They don't say the easement isn't real. Correct. She pointed to another paragraph. They don't say their permit authorizes them to block it. I kept reading. And they don't explain the site plan note requiring it to remain unobstructed, she said. It was the first time I understood that silence could be evidence too. Their lawyer had filled 2 pages with phrases like temporary limitations, construction sequencing, and safety compliance. But he never answered the central question. What gave them the legal right to lock me out of my own access road? Nothing, because there was no answer. Then my attorney gave me the next step. She said we were going to send a final notice, but we were also going to stop letting the developer control the setting. No more arguments at the gate. No more phone calls with receptionists. No more standing in dust while a foreman decided whether I was allowed to go home. The dispute needed witnesses with authority. She told me to request a civil standby from the sheriff's office if I had to pass through the easement and believed the developer might block or threaten me. She told me to update code enforcement with the surveyor's map, the site plan note, the locked gate photos, and the drainage trench location. She also told me not to touch their equipment, not to remove their chain myself, and not to give them any excuse to change the subject. Your strongest weapon, she said, is that you have been reasonable. That almost made me laugh, because reasonable had felt weak for weeks. Reasonable had felt like sitting in my truck while other people decided whether I could reach my own porch. Reasonable had felt like swallowing every insult so I would not give them a clip they could use against me. But now I saw what she meant. Every calm email made them look worse. Every photo made their excuse smaller. Every recorded document turned their confidence into a liability. 2 days later, code enforcement called me back. The officer had reviewed my complaint, the recorded easement, the photos, and the approved site plan. He said he wanted to meet at the site. He also wanted the surveyor present if possible. Then he asked whether access was currently open. I looked out my window. From the porch, I could see the top of the locked gate through the trees. "No," I said. "There's a chain across it again." He was quiet for a moment. Then he said, "Do you have the sheriff's office non-emergency number?" My stomach dropped, but not from fear this time. From the feeling that the fight had finally left the developer's private playground and entered a place where words had to match records. That afternoon, my attorney sent the final notice. That evening, I placed the printed easement, the survey map, the county site plan, the photos, the emails, and the security footage stills into one binder. I set it on my kitchen table beside my keys. For weeks, the developer had told me to find another way in. Now the county, the surveyor, the sheriff, and his own approved plans were about to show him there had never been another way around the truth. The morning everything changed. The road looked almost peaceful. That was the strange part. The sun had just cleared the trees, turning the dust in the air gold. A few crows were picking through the gravel near the ditch. Somewhere deeper inside the site, a diesel engine coughed awake, then settled into a low growl. If someone had driven by on the county road, they might have seen the gate, the orange barriers, the locked chain, and the heavy equipment, and thought it was just another construction project, starting another ordinary day. But I knew better. That gate was not ordinary. That chain was not ordinary. It was the line between a developer's confidence and a county record he thought he could ignore. I had barely slept the night before. The binder was on my passenger seat, thick with printed emails, photos, survey pages, permit records, the approved site plan, the recorded easement, and still images from my security camera. I kept touching the corner of it at red lights, not because I needed to check if it was there, but because I needed to remind myself that I was not walking into this with nothing. For weeks, the developer had made me feel small. One homeowner, one old house, one gravel road. That morning, I was still one homeowner. But I was not alone. The first person to arrive was the surveyor. He pulled in behind me, stepped out of his truck with his orange vest already on, and gave me a quiet nod. Then came the county code enforcement officer in a white county vehicle, with the seal on the door. A few minutes later, a sheriff's deputy arrived in a marked cruiser and parked where his dash camera could see the gate. My attorney was last. She stepped out carrying a slim folder, not the whole mountain of paper I had brought. That was her style. She did not need to look dramatic. She needed to be precise. The foreman noticed us almost immediately. He came out of the trailer fast, radio in one hand, hard hat tilted back, sunglasses already on even though the sun was barely above the trees. Two workers followed him, then stopped near the excavator like they were waiting to see whether this was going to become entertainment. "What's going on now?" the foreman called. The deputy answered before I could. "We're here regarding a reported obstruction of access." The foreman looked at me, then at the deputy, then at the county officer. His expression shifted just slightly. Not fear yet, but calculation. "This is an active construction zone," he said. "Nobody's allowed past that gate without authorization." The deputy nodded toward the chain. "Who authorized locking it?" The foreman lifted his radio. "Site management. Safety requirement." The county officer stepped closer to the gate and looked at the sign. "Do you have documentation showing this closure was approved by the county?" The foreman gave a short laugh, like the question insulted him. "We have permits." He walked to the trailer and came back with a laminated copy of the construction permit, the same one posted on the board. He held it out like a winning card. The code enforcement officer read it without changing expression. "This is grading, drainage, and utility work," he said. "Correct," the foreman replied. "This does not authorize closure of a recorded private access easement." The foreman's jaw tightened. "That road is inside our project limits." The surveyor stepped forward then, calm as ever, and pointed toward the orange flags still fluttering along the road. "And the easement is inside your project limits too. Those are not mutually exclusive." For the first time, the foreman did not have an immediate answer. Then the black SUV arrived. It came fast down the edge of the site, tires crushing gravel, dust rolling behind it. The developer stepped out wearing the same clean jacket from the first night, the same expensive shoes that somehow never seemed to get mud on them. He looked annoyed, not surprised. That told me he had been expecting escalation. He just had not expected it to look like this. He walked straight to the deputy. "Officer, this is a private construction site," he said. "We have a homeowner who keeps interfering with permitted work." My attorney opened her folder. The deputy looked at her. "Ma'am?" She handed him the recorded easement first. Not a summary, not a letter, the actual county document. "This is the recorded access easement, benefiting my client's parcel," she said. It predates the developer's ownership. The approved site plan also states the existing access easement is to remain unobstructed unless alternate access is approved. No alternate access has been provided. The developer let out a breath through his nose. This is a civil matter. The deputy looked at the locked gate, then at the only road leading toward my house. It became a public safety concern when someone locked the only access to an occupied residence. That was the first sentence that made the developer's face change. Only a little, but it changed. The code enforcement officer asked the developer directly, "Is there another approved route to this residence?" The developer hesitated. The foreman answered for him, "Not at this stage." "Then why is this route locked?" "Site safety," the developer said quickly. "We have heavy equipment operating. We can't have random vehicles moving through." My attorney's voice stayed even. "My client is not a random vehicle. He is the dominant estate holder under a recorded easement." The words sounded almost too formal for the dusty road we were standing on, but they hit harder than any shouting could have. Dominant estate, recorded easement, approved site plan, unobstructed access. For weeks, the developer had controlled the vocabulary, historical access patterns, temporary limitations, construction sequencing, safety restrictions. Now the right words were finally in the air. The deputy unfolded the easement page and began reading, not silently, out loud. He read the legal description. He read the language granting ingress and egress. He read the part identifying the road as access to my parcel. He read enough that every worker standing near the trailer could hear it. Even the engine noise seemed to fade behind his voice. Then he lowered the paper and looked at the developer. "Based on what I'm seeing here, this resident has a documented right to access his property through this route. You cannot just lock him out because it's inconvenient for construction." The developer's face went red. "No one is locking him out," he said. I looked at the chain hanging through the gate. The deputy looked at it too. No one had to say anything. The code enforcement officer took photos from several angles. He photographed the gate, the lock, the sign, the barriers, the equipment parked within the flagged easement, and the gravel pile narrowing the road. Then he walked with the surveyor along the flagged line while my attorney showed him the site plan note. I stayed back near my truck. Not because I did not care, but because I had learned by then that the best thing I could do was let the documents speak. The developer tried to follow them, talking the whole time. He said the closure was temporary. The county officer asked for the temporary closure approval. He said access could be coordinated. The county officer asked where that process was written and how emergency vehicles were supposed to coordinate with a locked gate. He said construction crews needed staging space. The county officer pointed to the site plan and asked why staging materials were being stored inside the easement when the plan showed it remaining open. Every answer the developer gave created another question he could not answer. Then they reached the drainage trench. It cut diagonally across the road near a low section where water already collected after storms. It was not huge, but it was deep enough that a normal car could bottom out if the boards shifted. The crew had laid temporary planks over it, then covered part of the area with loose gravel, as if making it harder to see made it less real. The surveyor checked his map and pointed with his pencil. "This is within the easement." The code enforcement officer looked down into the trench. "Is this shown on the approved drainage plan?" The foreman said. "It's field adjustment." The officer looked up. "That is not what I asked." The developer stepped in. "Minor drainage modifications happen all the time. Not across a required access easement without approval," the officer said. That was the moment the balance fully shifted. The developer was no longer arguing with me at the edge of a road. He was answering a county officer in front of a deputy, a licensed surveyor, and an attorney, while standing beside a locked gate his own permit did not authorize, and a trench his own plans did not appear to show. The county officer took out his tablet and began entering notes. The developer's voice lowered. "Is that really necessary?" "Yes," the officer said. "I'm documenting obstruction of access and work inconsistent with approved site conditions." The foreman muttered something under his breath. The deputy turned his head. "You want to repeat that?" The foreman went quiet. For the first time since this whole nightmare started, no one from the developer's side was smiling. The county officer told them the gate had to be unlocked immediately. The chain had to be removed from the easement access point. The barriers had to be moved. Any equipment or material narrowing the road had to be cleared. The temporary trench crossing had to be evaluated, stabilized, and reviewed against the approved drainage plan. Until then, the road could not be treated as their private staging lane. The developer asked what would happen if they needed to close it again for safety. The officer said, "Then you submit an access plan for approval, provide a lawful alternate route, and notify the affected property owner properly. You do not padlock an occupied residence off from the county road." The words sat in the air like a verdict. The foreman unlocked the gate himself. He did it slowly, with the angry stiffness of someone being forced to perform defeat in front of his crew. The chain scraped against metal. The padlock clicked open. One worker moved the sign. Another climbed into the excavator. The engine roared, the bucket lifted, and the machine that had blocked my road began crawling backward out of the easement. I watched it move inch by inch. It should not have felt emotional. It was just equipment moving off gravel. But after weeks of being told my rights were imaginary, after standing outside my own property like a trespasser, after walking home in the dark past machines that did not belong there, that small open space in the road felt like oxygen. The deputy walked over to me while the crew cleared the barriers. "You're good to pass through," he said. "Keep documenting if anything changes. Don't get into arguments. Call us if you're physically blocked again." I thanked him, but my voice sounded strange even to me. The developer stood near his SUV with his phone pressed to his ear, pacing hard enough to kick dust onto his clean shoes. The county officer was still taking photos of the trench. My attorney was speaking quietly with the surveyor, pointing at the map. For once, nobody was asking me to move, wait, coordinate, cooperate, or find another way. The road was open, but the day was not over. Because as the county officer reviewed the trench more closely, he noticed a second cut in the drainage line farther down, hidden behind stacked pipe and loose stone. Then he asked the foreman for the latest approved drainage revision. The foreman did not have it. The developer stopped pacing. The officer looked from the trench to the site plan, then back toward the construction area where fresh earth had been disturbed well beyond the marked lane. His tone changed. "I'm going to need to review this entire section of work," he said. The developer tried to interrupt. The officer raised one hand. "No, we're past the access issue now." And that was when I understood the developer had made the same mistake arrogant people always make. He thought blocking my road would pressure me into silence. Instead, it brought the county directly to the part of his project he least wanted them to inspect. The stop work order did not happen that morning. It happened 3 days later, and somehow that made it even more satisfying. At first, the developer tried to act like the county visit had been nothing more than a misunderstanding. By noon that day, the excavator was gone from the easement, the chain was off the gate, the orange barriers had been stacked beside the trailer, and a worker had spread fresh gravel over the worst ruts in the road. The developer never apologized. He did not look at me when I drove through. He stood near his SUV with his phone pressed to his ear, watching my truck pass like the road itself had betrayed him. For the first time in weeks, I drove all the way to my porch without stopping, without asking permission, without waiting for a foreman to wave me through like I was a delivery driver at someone else's job site. But the county officer had not forgotten the drainage trench. By the end of the week, 2 more county vehicles had returned. This time, they were not there for my complaint. They were there for the project. They inspected the trench across the easement, the second drainage cut hidden behind stacked pipe, the disturbed soil beyond the approved grading limits, and the temporary runoff path that had already started pushing muddy water toward my driveway after rain. The developer kept saying it was minor field adjustment work, but the approved plan said otherwise. A formal notice of violation came next. Then a partial stop work order covering the access corridor, drainage work, and the section of the site connected to that unapproved trench. For 3 weeks, the multi-million-dollar townhome project slowed to a crawl because the developer had decided one homeowner's recorded easement was an obstacle he could bully out of existence. He had to submit a revised access and traffic control plan. He had to submit a drainage correction plan. He had to show in writing how emergency vehicles, utility crews, deliveries, and ordinary residential traffic would reach my home during every phase of construction. The county required temporary fencing to keep equipment out of the easement. They required reflective markers along the edge of the road. They required a posted sign that said, "Private residential access, do not block." And every time the site schedule required work near that road, I had to receive written notice in advance. The same developer who told me to find another way in now had to ask the county for permission before placing so much as a cone near my access. My attorney handled the rest. The demand for reimbursement went through his legal department and his insurance carrier. It covered the license survey, the damaged gravel surface, the replacement address marker, missed delivery fees, part of my attorney's fees, and the drainage repairs needed near the bend where their trench had changed the water flow. They fought the amount at first. Of course they did. They called some charges excessive. They claimed the road was already old. They argued the address marker was inexpensive. They said the missed deliveries were not material damages. My attorney sent back the photos, the video, the county violation notice, the survey invoice, and the security camera stills of their workers removing the sign after dark. The tone changed after that. In the end, I did not get rich. That was never the point. But I was reimbursed enough to cover my real costs, repair the road properly, replace the address marker with a larger reflective sign, add a second camera near the gate, and pay down the legal bill that had kept me awake more nights than I wanted to admit. More importantly, I received something better than money. A written acknowledgement. The developer's attorney sent a letter confirming that my parcel benefited from the recorded access easement, that the developer would not obstruct it without lawful approval, and that all site personnel would be instructed not to interfere with my ingress and egress. I printed that letter and put it in the front of the binder. Not because I trusted them, because I trusted paper. A month later, the project came up during a county public meeting. I almost did not go. I had spent enough evenings thinking about that developer, and part of me wanted to stay home, sit on my porch, and listen to the quiet road I had fought so hard to keep. But my attorney told me public records matter, so I went. I sat in the back while the developer gave a polished update about revised drainage controls, improved site safety, and neighbor communication. He did not mention locking my gate. He did not mention the missing address sign. He did not mention the sheriff reading my easement out loud in front of his crew. So when public comment opened, I stood up. My hands shook a little, but my voice did not. I did not insult him. I did not exaggerate. I simply stated that my home had been blocked from its only legal access, that the easement had been recorded for decades, that the approved site plan required it to remain open, and that county enforcement had been necessary before the developer complied. Then something happened I did not expect. Another resident stood up, then another. One talked about mud washing into a roadside ditch. One talked about construction trucks ignoring posted hours. One talked about workers parking where school buses needed to turn. None of them had my exact problem, but they all had the same feeling. The developer had been acting like approval of a project meant permission to ignore everyone around it. The county board did not cancel the project. Real life usually does not end that neatly. But they did tighten oversight. They required more inspections. They required updated communication logs. They made the developer return with corrected drainage documentation before the next phase could move forward. 2 weeks later, the foreman who had called my deed old paperwork was gone from the site. No announcement, no explanation. Just a different truck in his parking spot and a new supervisor who introduced himself by saying, "We understand there's an easement here, and we're going to keep it clear." That was the closest thing to an apology I ever got, and honestly, it was enough. The road is still not beautiful. It still gets dusty in summer and soft after heavy rain. My porch still creaks. My mailbox still leans a little, even after I fixed the post. The townhomes are rising now beyond the trees, taller and closer than I would have liked. But every morning, I drive out over that gravel road without asking anyone's permission. Every evening, I drive back in. Sometimes I pass the sign the county made them post, and I remember the night I sat in my truck with an excavator blocking my headlights while a man in a clean jacket told me I had only gotten used to using my own access. He was wrong. I had not gotten used to using it. I had the legal right to use it. That was the difference he thought he could erase. People like that count on exhaustion. They count on you being too busy, too scared, too embarrassed, or too broke to fight back. They count on you yelling at the wrong moment, losing the right document, deleting the right email, or believing that someone with a bigger project automatically has bigger rights. But property rights do not depend on who has the nicer SUV. They depend on records, boundaries, surveys, permits, and the willingness to stay calm long enough for the truth to become undeniable. I did not win because I was louder than the developer. I won because I kept the emails. I saved the footage. I read my deed. I checked the county records. I hired the surveyor. I called the right offices. And when the moment finally came, I let the sheriff read the recorded easement out loud in front of everyone who thought I would just disappear. So if you ever find yourself dealing with an HOA, a neighbor, a contractor, or a developer who treats your driveway, your fence, your land, or your access like it belongs to them, do not give them the reckless reaction they are hoping for. Document everything, read everything, ask questions in writing, and never assume a small paragraph in an old deed is too small to stop someone powerful. Sometimes that paragraph is the only reason you still get to go home.